aspirants, here I am Pallavi Rai. I am here to discuss with you about the Limitation Act, and today we will discuss about the historical background of Limitation Act as well as the characteristic of Limitation Act. So, why did we need this law? Prior to the 1963 Act, the old law, the Limitation Act 1908, had become the subject matter of controversy in the bench of the bar, and the government of India was anxious since long to enact a new act in order to end the various controversies in the old law. So the old law was controversial at that time with the present situation. So uh, uh, Parliament has decided to introduce a new act, and so the bill on the Limitation Act in 1963 was introduced, and it received the assent of President of India on 5th October 1963, and thus it published in the Gazette of India on 5th October 1963, and after that this act came into existence, and this act came into force with the effect from 1st January 1964. The next we will talk about the characteristic of Limitation Act. The first characteristic, what is the object? What is the object of Limitation Act? The object of the act is to quite long possession and to extinguish state demand, and the object of act is not to create or define cause of action but simply to prescribe the period within which existing rights can be enforced in the court of law. And the principle of act is not to enable the suit to be brought within certain period but to forbid them being brought after certain period. So the law of limitations prescription are based on the principle that law aids the diligent and not the indolent. The man who has negligently slept over his right for an undue length of time will not be allowed to litigate in respect of them. So this is the first characteristic. Next one is nature of the act. Nature of the act. What the nature of this act is, whether it is substantive or a procedural. So we will see what the nature of this act is. So the nature of the Limitation Act is a rule of procedure, a branch of adjective law. The intention of the law of limitation is not to create a right where there is none, not to extinguish a right where there is one, but to interpose a bar after a certain period to enforce an existing right. Let's see, when the robbery debt is banned by the lapse of time, the right to debt is not extinguished, and if the debtor, without being aware of the bar of time, pays up, he cannot sue the creditor to refund the money to him on the ground that his claim for recovery of the debt had become time barred. So this the nature of the Limitation Act is procedural or adjective law. So then we will move on to the next characteristic. Next characteristic is its operation of the act, whether it is retrospective or prospective. So the general rule is that a statute of limitation, being a law of procedure, is retrospective in its operation and govern all proceeding from the moment of its enactment, even though the cause of action might have been accrued before the act came into existence. Therefore, the law of limitation is retrospective in operation. Now we will move on to the fourth characteristic, which is limitation only bars the remedy but does not extinguish the. So the Limitation Act is a law of procedure, and it doesn't either create or extinguish right except in the cases acquisition of title to immovable property by prescription under section 27. So the 27 is the exception of this rule. Characteristic is the Limitation Act is a civil law. It doesn't apply on criminal law, but Article 114, 115, 113 of Schedule of Limitation Act applies on criminal appeal. But the chapter 36 of CRPC deal with the prescribing limitation in which complaint can be filed. So the Limitation Act talks about only the appeal of criminal cases, but doesn't prescribe time limitation for it doesn't prescribe limitation for complaint or a FIR. Next characteristic is limitation act as a complete code. It is exhaustive. It doesn't depend on any other act to deal with, or it has no any other it has no provision which is saving provision, which saves the provision of other enactments or other acts. So it is a exhaustive act. It is not a limited act. So the next characteristic is doctrine of limitation is distinguished from doctrine of acquiescence. Doctrine of limitation is distinguished from doctrine of acquiescence. If a party having a right stand by and sees another acting in a manner inconsistent with that right and makes no objection, while that act is in a progress, he cannot afterward claim. This is the proper sense of the word acquiescence means here. So acquiescence may be direct and indirect. This is the difference of doctrine of limitation. Doctrine of limitation prescribes the period, whereas doctrine of acquiescence is just to be silent and let other interrupt. Next characteristic is burden of proof to plea of limitation. The onus of proof is upon the plaintiff, and he must show either that the suit is prima facie within time, or that be reasoned by minority, concealed fraud, acknowledgement, part payment, or other fact. The period of limitation has really expired and he is still within time. So the burden of proof as to plea of limitation is always on plaintiff, and it's shifted to the defendant, whom either shows that the case is governed by some special article which allow a shorter period of limitation than the plaintiff claim, or that particular circumstances exist which makes the period of limitation expire before the date on which the suit was instituted. And the last but not least characteristic of limitation act, the plea of limitation can be raised against plaintiff only. The general rule is that plea of limitation can be raised against plaintiff, not as against defendant. And main object of law of limitation is to prevent a person from seeking to enforce a statutory demand, and not prevent a person from raising any defensive likes. The defendant will not be precluded from setting up a right by way of defense. It could not have done so as plaintiff by way of substantial claim. So the plea of limitation can be raised against plaintiff only, because plaintiff have filed a suit with the lapse of time, after the lapse of time. So it is enough for today. We will discuss in the next part the sections of Limitation Act as well as Schedule of Limitation Act. So thank you.